suggestions, and we plan to do a lot more during this year.
Understand? Yeah.
Yeah.
And company secretaries are in the helm of affairs now for everything. So right from the Companies Act and from IBC and all. Many of my friends, my company secretary friends are all insolvency professionals, valuers. Now they are arbitrators. So such a vibrant times we are in now.
Correct. Last week or 10 days back, we had a webinar on company law settlement scheme and LL.B.
Oh, excellent.
So we called, Madam called the past president of CS Institute.
Okay.
So a lot of things. We had one more before that was on compliance part.
Okay.
Non-compliance and the issues relating to that.
Okay.
So we intend to do 2 to minimum 3 per month. That is the target.
Very good. Yeah. That's a very good approach.
Yeah.
The audience should not be over burdened with information bombardment.
Correct. And then these are all people who are into business community. They are not CAs or company secretaries. So we need to educate them. Ultimately, target is they are the business owners and they have to know what is what.
Absolutely, right.
And they take a call. They make decision. How much ever advisory part we do.
Yeah.
The decisions are from their side.
Sir, I need my screen sharing to be enabled so that I can share my screen and check it before we go into it.
Madam, ఒకసారి గోవర్ధన్ గారు పిలుస్తారా?
Okay, sir. 1 minute. I will call. Afternoon, sir. You can share, sir. No problem.
Share చేసాడా? Sir, you try once.
I'll try.
Yeah, try.
It still says the participant. I think I must be made a co-host. Only then I'll be able to share my screen. Isn't it not? In Zoom.
Yeah. Madam, వస్తున్నారు రెడ్డినా? గోవర్ధన్.
వస్తున్నారు సార్.
Okay.
Good evening, Kathy.
Good evening.
Good evening, madam.
Good evening. How are you?
Yeah, fine. President sir will join shortly, I suppose.
Still my screen share is not enabled.
Yeah, he's coming. He's
Yeah,
coming.
okay.
Is it enabled now?
No, madam, still not. No.
Okay.
ఇప్పుడు నేను ఈ హోస్ట్ ఇక్కడ ఓపీటీ నేనే ఉండాలి అక్కడ వేరే వాళ్ళు అంటే కష్టం మళ్ళీ ఇక్కడ మీకు ఆన్ చేయాలి కాబట్టి ఇబ్బంది.
Good evening, President, sir.
For the speaker, you give the screen sharing rights. They have PPTs.
Okay. This
No, not. He wants to share. You have to give him the admin right. No.
photo advance.
Settings can change. Settings. Yeah, madam. All panelists. All panelists. Yeah. Can you try now?
Yes, now it is coming.
Now it's there.
Yeah, my screen is shared.
Yeah.
Yeah, we can see it now.
Very good.
Good evening, President, sir.
Good evening.
Good evening, sir.
Good evening.
Ramakant.
Chairman, sir.
Good evening, sir.
I think it's 4. We can start.
Yeah, maybe we can start the initial part. We already have 20 plus delegates who have logged in, so
Correct.
start away for 5 minutes. Up to you, Chair.
We'll start, madam.
So very warm welcome to all our members who have logged in for this webinar on what business owners should know about the Insolvency and Bankruptcy Code. A very warm welcome to also our chief guest, Sri B.RAMANA Kumar, advocate and insolvency professional from Chennai. Thank you, sir, for accepting our invitation and agreeing to interact with our members. Welcome to our very dynamic chair, Sri Naresh Geli, from the Corporate Laws and IBC Committee, as well as Dr. Tasneem Sharif, co-chair, Corporate Laws and IBC Committee, and of course our president, Mr. Ramakant Tinani. So very warm welcome to all of you, and I now request our president to kindly deliver the welcome address.
Thank you, Ms. Khyati, our CEO. It gives me great pleasure to extend my warm welcome to today's speaker, Sri B.RAMANA Kumar, advocate and IP professional, Chennai, and my colleagues, Mr. CA Naresh Chandra LL.B, Chairman Corporate Law and IBC Committee, FTCCI, Dr. Tasneem Sharif, Co-Chair of the committee, and CEO Ms. Khyati of FTCCI. Distinguished participants, the Insolvency and Bankruptcy Code was enacted with a view to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate entities, partnership firms, and individuals in a time-bound manner. According to this code, when a default in repayment occurs, creditors gain control over debtors' assets and must take decision to resolve insolvency within a time frame of 180 days period. To ensure an uninterrupted resolution process, the code also provides immunity to debtors from resolution claims of creditors during the period. The code also consolidates provisions of the current legislative framework to form a common forum for debtors and creditors of all classes to resolve insolvency. Since its enactment in 2016, it has been amended 4 times to streamline the processes and address any lacuna to ensure proper operationalizing of the provisions of the code. While quite a number of provisions were amended and a few new more added, some of the notable ones are introduction of Section 29A, which bars promoter from bidding for their own companies to break the corrosive culture that allowed fencing of the distressed company by the promoters. According to home buyers, the status of financial creditors to give them a voice in the insolvency proceedings against defaulting real estate developers. Making adjudicating authority, that is AA, approved resolution plans binding on central government, any state government, and any local authority to whom the corporate debtors owes debt under any law, and barring termination or suspension of licenses and permits regarding the supply of goods or services. Our learned speaker will enlighten us on the resolution process under IBC. Thank you.
Thank you so much, Mr. Inani. I now request our chair of the Corporate Laws and IBC Committee, CA Naresh Chandra Geli, to kindly deliver the introductory remarks.
Sri Ramakant Tinani ji, President of Chamber of Commerce, Ms. Khyati, CEO, Ms. Tasneem Sharif, Co-Chair of Corporate Laws Committee, Ms. NVS Lakshmi, and my good friend CA B.RAMANA Kumar, Advocate and Insolvency Professional from Chennai, and to all the participants, good evening to each one of you. Friends, IBC is a very important code, which definitely helps a lot of business community. So IBC provides for a time-bound process on resolving insolvency. And to address this issue, the troubleshooting comes into existence, staggered insolvency laws in India, and to bring them under one umbrella, it is set up to face some monumental challenges and equally monumental expectations. When the default happens in terms of repayment occurs, creditors gain control over the debtor's assets and must take decision to resolve this insolvency. So under the IBC, a debtor and creditor both can start recovery proceeding against each other. Before this code, insolvency resolution in India was almost taking 4.3 years on an average, compared to United Kingdom of 1 year, USA of 1.5 years, South Africa 2 years. I'm sure the speaker of this evening, CA Ramana Kumar, would definitely take us through the nuances of this act, of this code, and also explain us as to what every business owner is expected to be prepared. And instead of taking it easy, you have to be very focused and forthright in handling this issue. And it's not a income tax notice or a company law notice which we can take it or ignore it for granted. So it's a very important thing. So I'm sure the speaker would explain the importance of it. Thank you very much, Kathy Madam, for giving the opportunity. Thank you.
Thank you so much, sir, for the introductory remarks. And definitely this is going to help our members in the long run. And I now request Dr. Tasneem Sharif, the co-chair of Corporate Laws and IBC Committee, to kindly introduce our speaker.
Good evening to all the members on the dais. Okay, so today we have a very distinguished speaker, a very diversified profile, and absolutely a dynamic personality with us, who will be taking through the business owner should know about insolvency and bankruptcy code. So I need at least 5 minutes to read the sir's profile. Let me cut short it, whatever I can read it. So, Mr. Ramana Kumar, by academic profession, he is a graduate in Institute of Cost and Works Accountants of India, that stands for ICWAI, and he is also a fellow member in Institute of Chartered Accountants. He is also an information system auditor from ICAI and also an insolvency professional. So currently, sir is enrolled as an advocate with Bar Council of Tamil Nadu and Pondicherry, and he has been practicing at Madras High Court, appearing on tax matters, corporate law matters. He is also appointed as special counsel by the CBDT for the Southern region in international tax and transfer pricing. He is also an independent director in the largest railway PSU, a faculty in Department of Management in IIT Madras. He is the co-founder for OvoPax Legal, which provides a variety of services, a bouquet of services in law, taxation, insolvency, compliances, real estate, business consulting, risk management, etc., etc., and etc. Okay, so then coming to his recognition and awards, he has been facilitated at the CFO 100 2012 event, and he received Outstanding President Award from Lions Club International. He has been given the Outstanding District Chairman by Lions Club once again. So to add a few more accolades to Sir's profile, he is a co-author. He is a regular contributor to the many magazines. He is a regular speaker, panelist, a paper presenter, and whatnot. Sir, we are so much delighted to have you on this platform today, sir. Over to you, sir.
Thank you, madam, for this generous introduction of mine. I thank the CEO of FTCCI, Ms. Kayati, the President, Mr. Ramakant Inani, and my very good friend and brother, a colleague, a comrade, and whatnot, Naresh Giriji. Thank you. Thanks a lot. And it's a great honor. In fact, you know, the place of Hyderabad brings emotion into me because my childhood was in Hyderabad, and you know, I was in Secunderabad for some time, and whenever I come to Hyderabad, I make a point to visit my old school, which is Kendriya Vidyalaya Picket. and also to go to certain other places which I used to frequent as a child. So of course, thanks a lot to the chamber for this lovely opportunity to interact with your members. I deem it a great privilege, honor, and pleasure to be with you here. And IBC is a very, very new chip on the block, new in the sense that I hope my presentation is visible now to everybody. Yeah. So yes, so what I would like to go here is, this would be the agenda for the day. The code, the requirement for the new law for the business people, and what is the principle behind the law. Of course, the president had rightly touched upon the situation to say that the creditors would be under control. So I would like to elaborate it. I would also like to touch upon the structure of the act, which is more important for the business owners to understand. And of course, the basic concept, there are some new concepts in the IBC law. For example, an operational creditor, operational debtor, corporate debtor, all these things are new. Financial creditor, all these things are new jargons which have been introduced here, which have to be understood by the business owners. And now the next one is actually the highlight or the climax of the talk would be what action can be taken against the business owners and how you should prevent that action, or how you must be ready to face the action, and how you must be in a position to retaliate the action. There are various parts to it, so we will discuss that. And also, what are the actions which the business owner can actually take against his creditors, people who have not been making the payment to the business owners, how he can effectively use IBC in order to get the dues to him. Be it as it may, in the outset, I would like to impress upon the gathering here that IBC is not a recovery mechanism. It is not a recovery mechanism, but it has been used by a recovery mechanism by very many people. But the intention of the act, which was actually touched upon by the president also, and I would also elaborate on it. The intention of the legislature is to effectively bring a solution to all the stakeholders. Stakeholders are the company, the employees, the landowners, the flat buyers, the other operational creditors, the banks, the government. Everybody is a stakeholder there. We are only trying to bring a maximization of the resources to each of the stakeholder in order to bring an effective resolution. Because earlier, if you see, whether it was a Sarfasi Act or whether it was the previous acts which were had, the factory which was unable to repay the money to the bank was locked. After the factory is locked, the case will go on for 25 years. In the meanwhile, what will happen in the factory? Either the factory or the plant and machinery will start to rust, or it will be pilferaged by various elements in the society. So the intention of the code, the Insolvency Bankruptcy Code, is to bring about a speedy resolution, which was again touched upon by the earlier speakers who introduced the subject to the audience, that to bring about a speedy resolution to the issue on hand, that is the non-repayment, on-payment of the debts and the inability to pay the loans to the banks and other financial institutions. And last thing would be is to just touch upon the corporate insolvency resolution process. In case we have the time, we will take it. Otherwise, we will just go by it. With regard to questions, I would appreciate the audience to mark the questions in the chat box. If it is of convenience, the host can, after about say 20 minutes or 25 minutes, we'll have a 5-minute session for question answers, and again we can continue. I think that must be a viable solution for both of us, optimal solution rather for both of us, in order for you to have the clarifications. I would only try to make a small request. Please pertain your questions to the topic we have covered, After we have covered the other topics, you can bring the other questions. Of course, it is not a trade secret or a rocket science IBC. By this time, many of the business owners, many of the attendees, many of the the members would have had either a taste of the IBC code or would have known IBC code in various manners. There would be a lot of clarifications. I would only have this small request to make. So with this, we'll jump into the topic. So the code and its evolution, how the code was evolved. Earlier it was the owner in possession until the sale of the factory. The example of factory which we took, until the sale of the factory, the owner was in possession of the factory. There was no, even though the bank would have sealed the factory, but the ownership remained with the owner until the complete resolution, and the complete resolution effectively entered in a sale of scrap of the plant and machinery invariably, and the value of land alone was the value which the banks could take it. So the limited liability company is a contract, as we all know, between debt and equity. As long as we are able to make the obligation towards the debt, that is the interest, the owners will have the control, and the creditors, the bankers and financial institutions will only have a situation where they would only collect the interest. Only when the default takes place, the complete thing reverses in a way that the creditor comes into control. All the creditors together will start controlling the company, and the debtor or the owner will have no say in the company, or will have an extremely limited and an extremely stunted say in the whole affairs of the business. This was the recommendation made by the Banking Law Reforms Committee in the year 2015, wherein the Banking Laws Reforms Committee was constituted by the Government of India to find a solution for the huge amount of NPAs which have been gathering, and the huge amount of non-repayments which have been happening over the years. So as a matter of history, it is important to understand that India is a land of entrepreneurs. Whether you take Dadabhai Nauroji, who actually built the first, the steel plant in India, or the great conglomerates which are there in India, like the Tatas, Birlas, and in the south there are many people, Adanis, whoever you take, they are in one side. The other side, if you see, the entrepreneurs, who are the entrepreneurs, who are considered as entrepreneurs, people who take risk on the ownership of the business, who take risk on the business, and they are not sure about the reward. Even the flower seller in front of a temple or a church or a mosque is also an entrepreneur of real sorts, because that individual takes a risk in doing so and trying to earn a living. We are not dependent like the other economies of the world. Indian people are not dependent on the government and the private sector for employment always. We have seen entrepreneurs everywhere. Even a kabadiwala is an entrepreneur. So India is a land of entrepreneurs, and in fact, the empirical studies have shown that the maximum per capita entrepreneurs in the world is in our land. So such being the case, where there is more risk, there is more reward. Where there is more risk, there is also more losses. The corollary of that is more risks also means more losses. So such being the case, where there are more losses, the government was actually, bothered in the sense that it had to do something with regards to the mounting NPAs which are happening. Not only NPAs as a business entity, even agricultural loans are failing, even personal loans are failing in very many cases due to whatever reason. So that was the reason why the government introduced the Banking Law Reforms Committee, and this was the study of the Banking Laws Reforms Committee, and that was the inception or the concept inception of the Insolvency Bankruptcy Code itself. Now, when we come to a situation where what was the need for new law? The need for new law was that in a situation of debt resolution, there were very many laws which have to be complied with, or which have to be undergone, and the government wanted to consolidate all these laws on debt resolution into one. There were multiple forums. You could go to a municipal court, you could go to a high court, you could go to a tribunal, you could go to an arbitration. There were various things which were there. And so the government wanted to have a situation to have a single resolution platform. The other important thing was the loans were issued, the loans were given only on the strength of the balance sheet, only on the strength of the projections, and not on the actual liquidity of the company. To see whether the company is liquid enough to have such loans was not in the scheme of things for giving loans at all, which became a very big issue in the later part. And there was no early warning system. There was no situation to find out whether a company is not doing well, a company is doing very well. Only on a post-mortem or on a balance sheet which was prepared on a later date, only the banks or the financial institutions, the lenders were able to, identify whether a company is going good or bad. A company means a business entity here. It may be a partnership firm, it may be a sole proprietary company, LL.B, whatever it is. There was no early warning system, and the banks were also not equipped to identify that there are some early warnings with respect to the performance of the company. There was no research wing in the banks to do all that. Of course, they considered it not necessary, but in other jurisdictions where it was one of the important functions of a bank is to identify where to give loans, where to not give loans, how to give loans, how not to give loans, etc., etc. And the debtor in possession is fought with conflicts of risk and processes. Obviously, there will be a court proceeding against him, there will be a DRT proceeding against him, there will be a company law liquidation petition against the owners, and all those things were there. Multiple conflicts were starting to come, which made the whole life of an entrepreneur, whole life of a risk taker into a very serious one. And another important thing, last but not the least, is the debt market. In the late 90s, when the NBFC was completely scrapped and completely killed by the government for whatever reasons is known, there was no system of parallel money lending into the system at all, which actually made the debt market stunted, and it was very scattered, and the interest rates were, the debt markets was very unregulated. Actually, it was not regulated at all, in the sense that the interest rates, ranged from there are interest rates which are even at 48% per annum, 4% per month was also the interest rate, which was a totally unviable system for any project for that matter. And because of all these things, you might all be aware that it impacted the global index of ease of doing business in India. India was in a very dismal state. The countries which were above India were Nigeria, Pakistan, Somalia, etc., which we consider as very, very poor countries. And even Bangladesh was far better than India in the year 2015 before the introduction of this law. So this was the background in which the new law was required, and where we had multiple laws to be complied with. These are examples of the multiple laws to be complied with. For partnership, you had Presidency Town, Provisional Act, all were historic, and Dadaji Ka Acts, 1909, 1920, all these acts were very old, and all these had to be consolidated, and a business owner had to undergo all these acts in order to have some solution somewhere, and that resolution was also very late, and it was either too little, because as we said, by the time the case was over, my factory is completely dilapidated, my plant and machinery are rusted, obsolete, and they cannot be reused, they have to be sold as scrap, only the land value was to be there. And as Mr. Kelly in his introductory remark said, that in Singapore it was only 0.8 years for a resolution, and in England it was 1 year, whereas in India the average time was at least 4 years. I think the people who have written this statement were very generous towards India, very patriotic, because 4 years is an understatement. 4 years, nothing happened, especially in India during those times. So how was the evolution of the code? Let us see the evolution of the code. In 1981, we had Sikh Industries Act. In 1991, we had the RDD BFI, and after that we had the Sarfasi Act. Nothing happened. All these three acts up till the year 1998, the Sarfasi Act was showing some amount of effectiveness, and that effectiveness also became to reduce once the cases started to clog in the DRT. I think the members who have undergone all this would certainly appreciate my statement to say that the Sarfasi Act was a draconian act in the sense that it was only talking towards the bank, and it was not with the borrowers at all, in the sense that the security or the security given by the borrowers were either completely sold in order to repay the bank, or they were sold at a very low rate, and also the personal guarantees of the borrowers were also invoked in almost all the cases, which led to a situation that people were really afraid to be an entrepreneur. People were really scared to have the children as entrepreneurs. The second line entrepreneurship started to reduce in the country. There are empirical studies to show that. And with the advent of the Banking Law Reforms Committee report in 2015, there was what we call now as a movement from the debtor in possession to the creditor in control. In fact, the Insolvency Bankruptcy Code is one of the fastest enactment which has ever happened in the history of this country, at least till that time. The Banking Law Reforms Committee was in November 2015. The Lok Sabha and Rajya Sabha passed the bill in May 2016, and it became an act by the end of May 2016. It became an act. It became a code. It was enacted. The president assent was given to the same, and it became an enactment. But be it as it may, again, the bureaucracy has shown their ugly fangs towards it to say that only one part of the code has been implemented in the last 4 years, which is a very sad thing. The other things also should have been implemented, the partnership and the other, the other parts of the code for partnership and sole proprietors and for individuals must also have been introduced. Due to whatever reasons, the government is keeping postponing it. Now, with the advent of the COVID-19 situation, I think in all probability this will still be postponed, because already the NCLTs and the DRTs are clogged with the applications which have to be disposed of, and as it is now, they are finding it very difficult to do that. And such being the case, we have to wait and see how the code is evolving. But having said that, we have to give a congratulatory note to all the stakeholders involved, including the government, IBBI, including the the practitioners and the business community. There are a lot of resolutions which have actually happened in the year 2017. In 2015, we were 191 or something, but in the year 2017, it reduced to 136, the ease of doing business. And in July 2020, this had taken for my IIT classes, which I wanted to include here. In July 2020, the rankings improved very significantly to 163. I think that's a very good one. No, 163 is something else. India is in the business rank. It had moved to 63 from 183 in 2017, moving to 63 in the year 2020 July. I think it's a great achievement. It's a great feat which has been done by the Indian public, Indian bureaucrats, Indian practitioners, and the Indian business community as such. So this is the basic statistics which we have, and the 63 is the business rank which India has now. Above India, what are the countries? We have Kenya above India, we have Chile, we have Mexico, we have Bulgaria above India. I think we should move up even more. I think we must come within the first 20 or 15, I should say. In all probabilities, we have to really appreciate ourselves, give a pat in our backs. So this is the basic history behind it. And now we come to the objective of a new code. Now with 2016, with the assent of the president, the code has come into force. And what is the objective of the code? Objective of the code, as you can see, which has been highlighted, is the maximization of the value of assets of such person to promote entrepreneurship, availability of credit, balance the interest of all the stakeholders. Balance the interest of all the stakeholders is an important bedrock on which the whole code is being enacted now and administered, because the interest of all the stakeholders, including the existing promoters, directors, employees, contractors, suppliers, lenders, the government, everybody have to be, there has to be a balance of interest between in all this. One is the objective of the new law. So the structure of the code is something like it, even though you don't have to know, a business owner is not required to know this, because all this will be handled by his consultant or by his insolvency professional or by his advocate, company secretary, whoever it is. But as a matter of information, you must know that there are totally 5 parts to it. Of the 5 parts, only part 2 has been enacted now, and a very limited issues in part 3, that is the corporate guarantors, individuals who are corporate guarantors have been enacted, and the individuals and partnership firm is yet to be completely come into force. There are some regulations which have been introduced, but it is not completely into force now. The other parts are all the administrative parts, and the part 5, the miscellaneous provision, deals with all the consolidation of all the acts, right from Income Tax Act, Companies Act, the acts which we saw earlier. All these acts are being consolidated into one code, and this miscellaneous part is a part which will actually make way for the consolidation of all the codes into the IBC code. So IBC code is it's an extremely important code. It is important that all business owners have a look at it, especially people who have companies, LLPs, and are in the corporate format, definitely have to go into the code. Our experience in it is the people don't get into it till such time the problem comes and hits them. Actually, the notices are not replied to on time, and it is a time-bound program. The IBC code, the administration of the IBC code, and the process is all time-bound. Earlier, it used to take years together. Now, these issues have to be completed within 330 days is the maximum period. It has to be completed within 330 days, and all the notices have to be replied immediately. You have a 7-day, 14-day window, after which the next action can be taken by each one. And there is also a window of only 45 days for an appeal, 30 days for an appeal, whereas for other enactments, say either an income tax or a GST, you have at least a position of filing the appeal with the condonation of delay. Here there is no condonation of delay, because the next action would have been performed either by the professional or by the government or by the agency, whatever it is. So such being the case, it is important that we know the nuances and at least the basics of the code in order to have a very safe journey ahead, and also face the music when it comes to actually. So the code mechanism is something like this. First is the act. The act is nothing but the Insolvency Bankruptcy Code 2016. After that, you have the board. The board is the IBBI, Insolvency Bankruptcy Board of India, is the administrating umbrella body of the code, and below that we have certain agencies. Agencies are all Section 8 companies under the various institutes of chartered accountants, company secretary, and cost accountants, who assist the board in enrolling the people, having disciplinary mechanism, checking the credentials, and gathering information as might be required. And in the bottom of the pyramid, which is the most important and the largest, are the professionals who are administering the Act and who are registered with the agency and with the board. So the adjudicating authority, earlier it used to be Supreme Court, Municipal Court, the District Court, etc. But now it is all NCLT. Each one NCLT is the National Company Law Tribunal for companies. For companies, it is National Company Law Tribunal. There are about 14 to 15 NCLTs in India. You have one in Hyderabad. Also, this NCLT is the adjudicating authority for all the corporate issues which come up. It is known as CIRP, Corporate Insolvency Resolution Process, and for which the NCLT is the adjudicating authority. For all other, for the partnership individuals, it is the debt recovery tribunals. Debt recovery tribunals are also available in very many countries, very many places in India, and one DRT is also available in Hyderabad. And another issue here is the utilities. So what the government is thinking is to consolidate all the loans. All the banks have come together and made this utility by which they will record all the loans given to individuals. They will record all the mortgages, the collaterals which they have, so that anybody wanting to give loan to these people can check the utility or the credentials. It's like a rating. It's like a civil rating which we had earlier, but in a more user-friendly and a more comprehensive manner, which would actually assist the people giving loans to do a background check on the person taking the loan. So these are the main code mechanisms we have. Before we go into the key concepts in relation to the code, if there are any clarification doubts, I'll be glad to take it. I'll just pause for a few minutes. If there are no questions, I will just continue. Otherwise, I will try to Q&A. There are a few questions. Can bank proceed against a debtor under the code when the matter is pending before the SARFAESI Debt Recovery Tribunal? Actually, once the application is made before the NCLT and the NCLT accepts it, there is a moratorium under section 14 of the code, which I'll be dealing with later, which actually prohibits any other action on the promoters, the directors, and on the company. Such being the case, where there is already a SARFAESI proceeding against the debtor in the DRT, the bank will not file the application at all, because the bank is assured the SARFAESI Act, the bank has the security, it will want to enforce the security and take the security. But what invariably happens is there would be another individual or another vendor who will be filing an application. If that application is admitted, this thing will start to be kept in cold storage till the completion. And by the time the CRP process ends and the assets are either distributed or a resolution plan comes into play, the application before the SARFAESI application would become infructuous. So that would be the situation here. So the other question is, what should be the treatment in case there is a variation in valuation? Okay, we will take up the valuation later. We have not come into the valuation at all. So key, if there are any other questions, I can take it. Okay, there seems to be none. Okay, so we will take the important concepts in the code. The Insolvency and Bankruptcy Code is triggered only on a default. There has to be a default for the code to be triggered. Otherwise, the code cannot be triggered. I cannot file an application stating that 4 months from now, my creditor will not repay me. So in anticipation, like an anticipatory bail, I am filing this application. No. There has to be a default. And only after the default can you actually trigger the code itself. And what is a debt? A debt is money or money's equivalent which has to be repaid, and it also includes a decreed suit where where a suit has been completed and it has been decreed also, that is also assumed to be a debt. As I said earlier, the Insolvency Bankruptcy Code should not be used as a recovery mechanism. That is the underlying understanding under which the whole thing works. It is not a recovery mechanism by which you arm twist the creditor. You either try to coerce him or come into some settlement and close the matter. No. Where there is a dispute, it is not a dispute resolution mechanism either. It is only a resolution mechanism with respect to the business. Where there is any dispute, say for example, I have not made the payment to my vendor for the following reason: the quantity is not right, the quality is not as per the specification and as per the purchase order, and it has not been delivered into my godown within the time accepted by the vendor to deliver it. Such being the case, where I have not made the payment to the vendor, there cannot be a trigger of IBC. Where there is a dispute involved, and this dispute must be recorded on a real-time basis. And one of the important things I would like to tell the business owners is that if you have a problem, if you have such problem with any vendor, please drop in a mail marking all your purchase people, all his marketing people, and also the owner of the owner of the vendor, stating that you have not complied with the conditions, you have not done ABCD work, because of which we will have to, either not make the payment to you or withhold some payment until to make the rectification. That has to be done on a real-time basis. And there are very many people, in fact, in my experience, people say, sir, he is my very good vendor, sir. For 20 years, I have been dealing with him. Everything happens over the phone only, and there is no record at all to say that there is a dispute. But actually, you see these photographs, all these things are broken. I cannot make the payment. I only informed him over the phone and WhatsApp that I will not make the payment. I don't have any records. So please, friends, wherever there is a dispute, and if it is a business dispute, it is important, it is extremely critical to record that dispute in the way that tomorrow if the other person goes to NCLT or issues you a form, which I will be coming to it later, a form 3 stating that you have to make so much payments to me, I have made the delivery of goods. That time if you say you have a dispute, the NCLT would not be inclined to accept your pleadings. So it has to be recorded earlier itself, beforehand, and on a real-time basis. One needs to record the disputes, if any, and that would be a great safeguard to all of us. And we have a unique nomenclature, as I said earlier, is called the financial creditors, and it's also the operational creditors. The financial creditor is a creditor who has given you money in order to exploit the time value of money. An easier way to say that, he has given you money on interest. He has no interest on the business. He has only interest to recover his money, or to recover his interest, or recover money and interest, as the case may be, as per the agreement he has entered in with you. So such people are called the financial creditors. Earlier, in an accounting or an auditing jargon, we only know secured creditors or unsecured creditors. We only know MSME creditors, non-MSME creditors. A new concept has been created here as financial creditors and operational creditors. Having explained the financial creditors, who are the operational creditors? Operational creditors are all the creditors who have taken part in your business. They have given you the parts, they have given you raw materials, they have provided you services, they have issued services to you, they have made some efforts in your organization and taken part in the business. Fortunately or unfortunately, knowingly or unknowingly, in the IBC regime, the financial creditors invariably hold an upper hand rather than the operational creditors. Operational creditors have got no say in the running of the business once it comes into the from a debtor in position to a creditor in control. The creditor in control is only the financial creditors in control, and the operational creditors are not in the game at all. They have to sit outside the ring like you are all. How the IPL would have also started. If you are viewing the IPL from the stadium or from the TV, the operational creditors would have to see what is happening to the company, how the financial creditors are actually administering it and managing it only from outside. They are not allowed to go into the actual play in most of the times. But where there are no financial creditors at all, everything is only operational creditor, the company has been so effective that it has got zero bank borrowings. I am an insolvency professional of a company in which there are no bank borrowings. All the bank borrowings have been settled. They have only operational creditors. In such case, 18 top operational creditors of the company will form a committee called the COC, which will actually administer the whole company as a creditor in control. Insolvency, bankruptcy, liquidation, calm period. Calm period is another interesting thing to say. Like the president also made a mention about it. The moratorium. The moratorium has been introduced to say that please wait. The company is in trouble. There is somebody called the insolvency professional trying to assist, trying to resolve all these issues. So please wait. There cannot be any more problems to the owners. There cannot be problems to the management. There cannot be any more problems to the creditor who are in control. Committee of creditors which actually control the company. So there is a moratorium, which is a calm period wherein no case can be filed against the company. So that is the calm period. And the committee of creditors, I have explained, adjudicating authority, we have also made a mention about it. Now, we have the definition of a few things. I don't want to go into all this. We will see when we have the time. In case we have the time, we will see we are already 1 hour into it. And a claim. What can it be a claim? A claim is a right of payment, whether or not such rights is reduced by judgment, except disputed, undisputed, legal, equitable, secured or unsecured. Anybody can make a claim. It is for the IP to decide whether there is any dispute or not in that, and accordingly close the matter. Now we will go straight into what the business owner should know about practical aspects in the whole code. First is action against the business owners. You are the company, and your creditors are against you, trying to file a claim against you in various matters. The company may be doing well, may not be doing well. In fact, there is one very interesting case, VA Tech Webag, where the Chennai NCLT, it was actually a running company, it was an MNC company doing very well. And there was an action against this company by some creditor due to whatever reason. And the application was admitted. So it is not necessary that only for companies who are unable to pay their dues, all these issues will come. Even for running companies, even for good going concerns, also these issues will come. So now we will see what to do when there are action against the business owners. So the action against the business owners, first what will happen if the action is from the creditors? The creditors, I mean, is the operational creditors. It is the biggest headache It is like the mosquitoes biting it at 4 o'clock in the morning when there is power shutdown. It is actually a nuisance value, but one needs to be very careful about it. Sorry, to do. So what happens when there is an action against the company by the operational creditors? Operational creditors, as we seen earlier, are the vendors or the people who have provided goods and services to the company, where these people, the amount is not paid. First, what will happen is there will be an issue of Form 3. The company will be visited with a registered letter or with a courier, invariably a registered letter with an acknowledgement due, which will contain Form 3. Form 3 is a form where it will say that you owe me so much of rupees for this so much of invoices which is enclosed. So the Form 3 will have all the invoices and the details. There are some people who also include the purchase order and also the email communications, which will form the form of the Form 3 and ask the company to make a payment. Invariably, what happens is that these Form 3s will go into the hands of the middle management and there is no action on it. Invariably, it happens. We have seen, especially in the earlier days of the code, where the people were not aware of these provisions. They were just thinking that somebody has given a vakil notice, so why should we even reply to it? And reply was not happening to it. So only where there is no dispute, the business owners, the company, the management, the promoters, the board of directors have to be worried. If there is no dispute and the amount is actually to be payable, if it is not paid, these people have to be worried. But if the non-payment of the money is due to any dispute, immediately there has to be a retaliation, there has to be a reply. They have to object to the Form 3 file by telling that there is a dispute. ABCD are the reasons. As I said earlier, the quantity was not right, the quality was not right, it was not provided, and we have the email to this effect. Once if we give that, this Form 3 will have a natural death. And even if case after the Form 3 they take it to the NCLT, it will be a situation wherein you will not be able to proceed against me, and there is a safeguard which is inbuilt in the code to say that wherever there is a non-payment due to a dispute, the code will not interfere on this problem. It is a commercial dispute between the vendor and the company. Assume there is no dispute at all, the amount has to be repaid. Kindly settle the creditor ASAP. It's not like earlier, you give a post-dated check, that post-dated check is not honored, then what happens? He files a 138. After he files a 138, you drag the case. Now it is not so. It is within the rights of the creditor to wait for 14 days for after issue of Form 3. If you have not replied to the Form 3 within 14 days stating that there is a dispute along with an evidence to show that there is a dispute, this creditor can immediately proceed against the company. Once the creditor proceeds against the company and the application is admitted, an insolvency professional is appointed and the board immediately stands suspended. The board immediately starts suspended. All the directors become the suspended directors of the company, and it is the insolvency professional who will take control of the board along with the committee of creditors. Please don't let it happen. There are very many companies which have actually done that, and they have faced very big problems and they had to come on. Only after all this Section 12A was introduced, by which, where I am able to make a settlement anytime during the application or immediately after the application is admitted, the application will be withdrawn and will become infectious. So Section 12A has been introduced at a point when the companies were actually, the corporate debtors were actually facing this music because of lethargy, non-availability of personnel, without knowing the law, all those things, what happens? The Form 3 is not replied to, and the creditors will proceed against the company before the NCLT, which takes matter very, very seriously. Please don't take the code lightly. If you have any problem, kindly consult your the consultant or an insolvency professional immediately on this. There is no harm in that. Please don't take the code lightly, because the repercussions, the after effects of admission, sorry, because the repercussions and the after effects of admissions are very, very serious and very fatal also at some point in time. Now we come to a situation where we have the financial creditors. The financial creditors, who are the banks, NBFCs, people who have lent you money for interest, all these people did not issue Form 3 at all. So please be very careful with them. Such non-repayment of principal, non-repayment of interest, and non-repayment of either of the one, the Form 3 is not required. They can file it directly under Section 7. The application is directly filed under Section 7. Now, all of us, should I pause for some time for any clarification or any doubt? Let me see if there are any Q&A. No, I have only one on the valuation, which I will take at a later point in time. So the other important thing which was in the news is, the home buyers. The home buyers are special status. They are not financial creditors. Technically, they are not technically operational creditors, but in a special status. And so for the home buyers, now the government, now the act is, the act has been amended to include the home buyers also as financial creditors, but with some special status, and they will appoint an authorized representative. And this home buyer issue will come only for companies which are real estate companies. So these companies have to be very careful with respect to the completion of the project. Of course, the home buyers also would not dare go to the NCLT on small pretext, because they should be aware of the fact that the project will get stalled at least for that 330 days or till at least Section 12A, where the application has been is to be withdrawn. So the home buyers, there is an inbuilt check and balance to say that only under extreme circumstances the home buyers also would go against the building company. So these are the actions which a creditor can take against the company. Now we will see what are the actions which a business owner can take. One of the largest problem which any business owner has is the cash flow. There is always a crunch of cash flow. The receivables are not received on time, but for the payment, we need to make the payment much on time, wherein there is always cash flow crunch in the business. So only to tide over the cash flow, there is a CC limit or an ODO CC limit or whatever limit with the banks, which are used by the businesses in order to hide the situation. There may be situations where you have to receive money, from a lot of money, and this money has been due for a long time. Please understand, earlier the limitation was not applicable. The Limitation Act was not applicable earlier. Now the Supreme Court has made a precedent to show that the Limitation Act is very much applicable. So the Limitation Act here with respect to debtors is 36 months. So you need to proceed against the debtors in 36 months in order to effectively make a case against in the NCLT. So what you need to do first is, I would actually motivate each of the business owner to take out the balance sheet, make a list of the debtors who have not repaid the company, or they have not made the payment for a long time, and rank it between 1 and 5. And where there are cross non-repayments, they can immediately proceed against the debtors in Form 3. They can issue a Form 3 to the debtors. While issuing a Form 3, one has to be very careful. One has to be take care that there are no disputes. It is only a pure non-repayment of the debt, of the invoices which has been sent by you, and there is no dispute on that at all. Wherever there are disputes, I would strongly recommend not to file, not to send Form 3, because like you will be contesting the Form 3 where there are disputes. The other party would also be obviously contesting where there are disputes. And in case of operational debtors, ensure that there are no disputes. Form 3 to have all the invoices and details. Like the previous one, please ensure that the Form 3 has. See, for example, you have been dealing with this particular vendor from the year 1985. It is not required that from 1985 till date, all the invoices, all the details have to be kept. Assuming that only the last 5, last 6 or the last 8 invoices are pending, those invoices, those pending invoices alone can be kept. In case there is a running account where the invoices are being given to him on a regular basis, but the payment comes in ad hoc basis where you have to adjust the first invoice first and the second invoice next. In such cases, what one needs to do is be careful, take the advice of a professional and make the Form 3. And in Form 3, you can also claim interest. You can claim interest also from the vendor, in the sense that there must be a clause of interest in the agreement or in the invoices. So please kindly go back, look into your invoices to see whether you have a clause of invoice. For example, if the invoice is not cleared within 60 days, the company can, the company is at a liberty to charge interest at say 12%, 15%, 18%, as the case may be. So unless there is a provision for the interest in the invoices, the interest amount cannot be included. Be it as may be, if you take large amounts, if you say a crore of rupees is pending for the last 24 months, even if the rate of interest is 12%, so there will be an interest. We can actually charge an interest on the outstanding to the tune of 24 lakhs, which is a substantial amount. These things will make the other party to come for a one-time settlement, to a compromise, to a reconciliation with us in order to take the money. So it is always advisable to have the interest clause embedded in the invoice itself, which will have a very good advantage in case of an IBC proceedings. So one needs to wait for 14 days before filing the application. So either 14th day, if the other party does not come for a settlement or for a reconciliation or giving even PDCs or whatever, so one has to be ready with the application to file the application before the NCLT. Please remember, filing an application for an operational creditor is a thankless job. Thankless job, and I'm using the phrase for the simple reason that you don't have a place in the COC for filing a application against a operational creditor. I'm sorry, it's not operational creditor, it is operational creditor. So there is no place for the there is no place of the operational creditor in the COC of the corporate debtor. As we discussed earlier, it is only the financial creditors who can be in the COC. That is number one. Number two is you have to have the additional expenses. Already he has not repaid you a crore. Already you have included the 24 lakhs as interest. Already there is an outstanding of 1.25 lakhs. On over that, you will have to incur expenditure in filing the application. You will have to pay the IRP at least for the first month, where the interim resolution professional is appointed. The payment has to come from the corporate debtor or from the applicant who makes the application. Of course, it can be reimbursed by the COC at a later point in time, but you need to pay it for such time. And the other expense includes the public announcement, where immediately within 3 days the insolvency professional or the interim resolution professional has to make one public announcement and an advertisement in an English newspaper as well as in a vernacular language newspaper stating that this company has come into the corporate insolvency proceeding process, and that expense also has to be borne by us, and also the first COC meeting. We are not looking at, keeping the meeting in say Taj Krishna or somewhere else, but we are trying to see that there will be at least a small amount involved in having a COC meeting, especially where there are more home buyers, 40-50 people come into place, you need to place to sit, and all the expenses have to invariably be borne by the person filing an application. This is not I'm not trying to dissuade anybody from filing the application. I'm only stating the fact. People will be agitated to say that already I have to receive so much money, again I have to spend money to file an application. Yes, you have to. Yes, after filing the application, do I have a surety in getting the money? No, you don't. If you don't have the surety in getting the money, can I at least take part in the committee of creditors meeting? No, you can't. You are not even allowed into the committee of creditors meeting. This is the position of an operational creditor presently. For whatever reasons, the framers of the code have thought it so like this, that they would not give any undue or any cleavage to the operational creditors. Is it the same way in the other jurisdictions? No. In England, in the English bankruptcy code, the operational creditor has got much wider powers, much wider opportunity to get back his money in a much structured manner, whereas here you don't have that kind of a situation. So now we come to where there is a financial debtor. You have given money to somebody else as a loan. You have given money to somebody else as a loan. It is not required that one has to be an NBFC or the company having the main objective of money lending. In case due to whatever reason the money has been given, even an advance has been given to another person for certain things which is converted into a loan or which is backed by a pro note or an agreement to that effect, he becomes a financial debtor. For a financial debtor, you don't have to pay it at all. There is no Form 3, Form 4, nothing is that. Straight away one can apply to the NCLT. And here, as we discussed earlier, you will also be part of the committee of creditors. However, the percentage of voting will depend on others. Say, for example, you have given a loan of 1 crore, whereas at bank, the other banks, the consortium banks have given 49 crores. So 98% will be the banks or the consortium, other people, and our voting share will be 2%. So one has to be careful about that also. But be it as it may, you are part of the COC at least. You can administer the company and you can play your part in the administration of the company. So here what I would advise, where there are financial debtors, where you have given note, try to settle them in OTS or PDC. Anyhow, you will have to spend some money in the sense that you will have to file the application and do everything. In all cases, both either as an operational creditor or as a financial creditor, it is always advisable to settle the matter rather than trying to agitate the matter before the NCLT, unless it is completely you cannot prevent it. I would very seriously advise people to go in for a settlement and close the issue. And there is another situation here where the company has committed a default. Either it has not repaid its operational creditors, or the company has unable to pay the loans to the banks, and it has come to know, instead of waiting till the NPA classification and the bank giving you a 13-2 SARFAESI notice, 13-4 possession, instead of waiting for all that, the company can itself lift his hand to say, you can file an application. The company itself can file an application to say that I want a CARP, I want an insolvency resolution process to happen. by which I can come out of the present situation. This is a new thing for India. But you know, in the United States, it is a very common thing. In fact, the president of the United States or the ex-president of the United States, we know within a few days. But let me say, Donald Trump has undergone this resolution process for his companies thrice. Only in India, people, you know, cling on to that company in spite of making losses, in the sense that they ultimately lose everything in the company, and also the collaterals are enforced at a later point in time. So the IBC, the Banking Law Reforms Committee, in its report had also recommended that where a default is committed by a company, the company can itself approach the NCLT to say that, see sir, I have committed this problem, I have committed this default, I would like to have the insolvency process undergone on the company and come out of the company, rather than, you know, facing the music from all sides and ultimately suffering. So it is actually a preemptive or a proactive action taken by the company in order to safeguard the assets, safeguard the peace of mind of the directors, and enforce a moratorium under Section 14, the moratorium which I was talking, the calm period. Instead of others infusing the calm period by influx of time, we can infuse the calm period ourselves in case of a default. These are the advantage we have. And where you are not, it was also this Section 29A was also mentioned by the earlier speakers, where you are not classified as a willful defaulter. In this case, there is no opportunity for the bank to make you a willful defaulter, because before the NPA has happened, you have lifted your hands and gone to NCLT. Such being the case, where there are no concept or there is no danger of being classified as a willful defaulter, the management is in a better position to take back the company, or, you know, apply for the resolution process by which the 29A will not be come into force and they can escape it. These are the advantages which we have. It is known as a Section 10 application. Incidentally, the financial data application is Section 7. Notice is given under Section 8, and the application by the operation data is made under Section 9. In fact, you don't have to note down any of these things. I will be, Mr. Gelly, the chairman has instructed me to share the copy of the presentation to the chamber, which I will be gladly doing it. After the presentation, I will convert it into a PDF and I will share it, which can be shared to all the members for any clarification and for consultation as well. So this is what I said. 7, 10, 7, 9, 10 are these are the important sections which one must know. Only 5 or 6 sections, I think these are important to understand. 7, 9, 10 is the application by the various stakeholders. Section 7 is by the financial creditors. Section 9 is by the operational creditors. Section 10 is by the corporate debtor himself. So these 3 are important. Section 12A, the withdrawal of application, where the corporate debtor is able to repay the money, strike an understanding, come to a settlement. In that case, what would happen is the application can be withdrawn, and the section for that is Section 12A. The other one is Section 14. Other one is Section 14. We'll have to wait for 1 minute. Sorry, there was small disturbance. And Section 14 is the calm period. The calm period is called the moratorium. And once the application is admitted, immediately the moratorium is settled in, and there cannot be any action against the company, against the corporate debtor by anybody, including any financial creditor, operational creditor, SARFAESI. None of that can happen. And Section 29, as we rightly said earlier also, are the individuals who are not eligible to be the resolution applicant. Only in India we have this restriction for various reasons, because the bank loan is being taken by very many people in order to defraud the bank. Such being the case, on a lower settlement, the management should not be able to take the company under control due to various reasons, because of which Section 29A has been introduced. But of course, it's a double-edged sword by which even the individuals who are able to genuinely, try to do the business and who have genuinely failed to do the business also are, affected by it, or which you cannot have an option at all. And Section 53 is called as the waterfall. Section 53 is called as the waterfall. In case of a liquidation, how the money is distributed amongst the various stakeholders. In fact, earlier you would have noticed that either in the Sikh Industries Act or in the Sarfasi Act, the first person who will come to take the money is the government. You will have to pay the balance of income tax, you will have to pay the balance of sales tax, you will have to pay excise duty, penalty, provident fund, ESI, income tax. After all this, nothing will be left for anybody to take it. So such being the case, the distribution of assets was like that. Earlier, the government dues were given priority. Now, in the Insolvency Bankruptcy Code, the government dues has been reduced. It is now in the 4th rank or in the 5th rank. The first one is the secured creditor who has all the security of the property. So the first priority goes to the secured creditor who has actually created a charge, who has the mortgage, etc. Only the first has it to the secured creditors. After that, you come to the employees of the company. If you are a workman, the workman will get 24 months of salary. If they are employees, white collar, the computer operators, secretaries, etc., they will get the salary for 12 months. So that is the second waterfall. After the water has fallen on the security, on the secured assets, when the water is trickling down, then it will trickle down to the employees and other people. So such that it will keep trickling down. After that, the government. The 5th one is the government along with the operational creditors. Only if there is any balance left after that, it will be the financial, it will be the operational creditors and the government. Mr. LL.B has raised his hands, but I don't know whether he will be able to speak. Do unsecured loans have any special status? Yes, unsecured loans will also have a status, but it is not equal to or at par with the secured loans, and it is above the rank of an operational creditor and the government dues. So this is the way where an unsecured loan will be sitting. So should I offer some time here for any clarification? Would you be opening the mics for the participants to interact, or should they only do it in the Q&A, madam?
They will not be speaking, sir. It will be only through Q&A.
Understood. So I would request people to put it in Q&A. Will personal assets also be under scrutiny? The personal assets will be under scrutiny so long as there is a personal guarantee issued by the guarantors. So what happens is the banks, even though there is a concept of limited liability for a company, the banks, while issuing a loan, will not only take the collateral but also the personal guarantee of the various directors of the company, by which if it is not repaid, the personal loan, the personal assets are liable to be attached as well. Now coming to 53, there was one question in 53. The first expense is, of course, the liquidation cost which has been involved. Next, and the worksman due and the employees due are the second one. Third one is the wages and unpaid due to employees other than workmen for a period of 12 months preceding. So the first 12 months is on priority. The second 12 months for workmen is given afterwards. And if the fourth stage in the waterfall is the unsecured creditor to whom it is paid. After that, you have the government and the other threats which will come into play. So this is the waterfall mechanism which is being followed in case of a liquidation. And these are the important sections one must know to know. And now I'll stop here for some time. Really, if there are any questions, we will take. And the others are all with respect to the code and how it is being administered. It can be done through a self-study also. In case I have time, I will take it. Otherwise, we will try to share it. Anyhow, I'm sharing all this with you. So I think on the practical aspects, if there are any clarifications, I'll be glad to take it right away. Is it fine, sir? Is it fine that we do like that, Mr. Gilly?
Yeah, sure, no problem. Now, there are two questions in Q&A. So I think, madam, you can read them.
What should be the treatment in case there is a variation in valuation or value of assets as appearing in the balance sheet of the corporate debtor and the physical verification done by the valuer or other agencies? This question often arises and stall the recovery proceedings. This is from Mr. Ranganathan.
Okay. See, once the COC has been constituted, the 30th day from the admission of the application, the committee of creditors is constituted. The first meeting of the committee of creditors happens. And in the first meeting of the committee of creditors, the resolution professional, from an interim resolution professional, a resolution professional is appointed. And the resolution professional, first what he must do is he must appoint the valuers for the company. There has to be two valuers, and whether whatever is the value shown in the balance sheet is, just kept aside, and an independent valuation made by the approved valuers, and that value, the two values will be compared. If there is significant variation in the two valuation, a third valuer is appointed only if it is required. Otherwise, it is not. So it is with the valuation report of the valuers will the whole issue will start to play, in the sense that there will be separate valuation for the land and building. There will be one separate set of valuation for plant and machinery, and a set of valuation for the assets of the company, whether it is a going concern, not going concern, all those issues will be taken. There will be a variation between the value of assets as in the balance sheet and the valuation of assets as per the valuation report, for the simple reason the valuer ascertains the liquidation value. The liquidation value of any property is much lower than its actual value. All of us are aware of it. So such being the case, stalls the recovery proceedings. Recovery proceedings may be stalled from a surpassing point of view, but with respect to an insolvency point of view, what happens is once these valuation reports are gathered by the insolvency professional or the resolution professional, as the case may be, the resolution professional will issue an information memorandum. The information memorandum will have all the information for an individual, for a person, for a company, for an entity, or for an organization or association to make claim in the assets of the company and take it as a running concern. So what will happen is the information memorandum, with the information memorandum, once the resolution professional receives the various offers from the applicants, resolution applicants for a resolution of the company, that will be compared with the actual valuation reports which we have, and that will set the basis for the insolvency professional to recommend to the COC whether to accept A, B or C resolution plans which have been given. So that is an important aspect to it, and so that is the importance of valuation. Recovery proceedings, yes, in an other enactment these things will be there, but with respect to IBC, the valuation report has got great sanctity in the sense that it may have any value in the books, but the valuation report is a liquidation value which the valuer has provided, which will take into the consideration. Can a company go for insolvency in case of failure of horticulture crop eucalyptus? There is no bar to say that agriculture should not come into insolvency. As long as it is a corporate entity, it can indulge itself in an CRP process. There is no harm or a bar in that. In the above case, the bank is silent on request for change of crop pattern by the company. I'm not able to understand this point. In the above case, the bank is silent on request for change of crop pattern by the company. I don't know what it is, but from what I have seen in various other jurisdictions, you have to explain that, Mr. Janardhan. I'm not able to understand that. But in other jurisdictions, the banks have an independent cell to recommend if you want a change of crop pattern because of the environment or for various reasons. There is some input from the bank also, but in India you don't have such an issue. Public announcement by the adjudicating authority. What shall be included in the public announcement? And is there any opportunity for the application to prescribe specific information in the public account? There is no specific information. You have a format. The format is called Form A. Form A is the public announcement. It is not issued by the adjudicating authority. It is issued by the interim resolution professional. Within 3 days of appointment, this public announcement has to be issued. It has to be issued in one English newspaper and in one vernacular language newspaper. And in case the resolution professional feels that it has to be issued in other areas also, it has to be issued. And what will the public announcement contain? The public announcement will contain the name of the corporate debtor, the name of the company against which the application has been admitted, the address, the name of the insolvency professional, the insolvency professional's address, and the insolvency professional, by way of this public announcement, will request for claims to be submitted before him, so that the claims have to be submitted within 14 days. So that from the 21st day till the 30th day, the interim resolution professional has got a week to examine and accept the claims of whatever, and based on these claims only he will form the committee of creditors. The first committee of creditors has to happen, the meeting has to happen within 30 days of the admission. So such being the case, the public announcement will have all such informations, where they can do the claim and in what format. All those links will be provided. It is an structured format which has been issued by IBBI, and one has to use that. I think I'm clear, sir. Sir, can you provide an example of a loan amount being in excess of final valuation and X steps? Loan amount being excess of final valuation. All the loan amounts invariably will be of final valuation, because where the collateral say there is a property for 1 crore and the loan has been issued say for 75 lakhs by the bank, and over the years the interest has accumulated, the penal interest has accumulated, blah blah, whatever charges has accumulated. Now the value of the loan is 1.45 crores, assume that. So such being the case, the value of the loan is in excess of the final, is in excess of the valuation. Now if I value the property, say assume for the COVID situation, I do a valuation of the property, I will not get 1 crore, I will get only 90 lakhs. So such being the case, the valuation is for 90 lakhs, whereas the amount to be repaid by the individual to the bank is 1.45 crores. Nidhi application cannot do it, sir. There cannot be an application from the Nidhi companies to do chit funds, cannot do this. As of now, it is not being accepted. There are a few cases it was accepted earlier, but where the main business is lending of money, such companies cannot go into IBC. I think Mr. L.N. Reddy, I have clarified. If you need still any clarification, you can please write in the chat box. Anil Madhavan, in the context of COVID-19, whether the previous LGNT program supposed to be completed in 180 days, which have lapsed, and with extension of time is allowed, at least whether the liquidation of a listed company admitted earlier to COVID-19 is February 20, whether Mr. Madhavan, I think you are talking about my company itself. Exactly the same dates. February 2020, I have applied for liquidation for one company, and even today that application is not being taken up by the NCLT. So such being the case, this delay is invariably condoned, and for the purpose of COVID, because of the lockdown and for the shutdown, about 150 days to 200 days have been lapsed, and that is not taken into account by the NCLT for the purpose of the dates at all. And one more important thing, any action taken by or for a company after 25th of March till a date to be announced, I think it has been announced, I don't remember the date, you cannot proceed under NCLT at all. So from 26th March 2020 to say October or November 2020, whatever has been the lapses, you cannot proceed against IBC. That doesn't mean that you cannot give a police complaint. That doesn't mean that you cannot go under SARFAESI. Doesn't mean that you cannot go to an EOD action. But IBC has shut the doors for all defaults which have happened after 25th of March for a period of 6 months. So that is one important thing which you should know. Whether there are any days extended in this liquidation process, yes, automatically it has been extended. Automatically it has been extended, and till such time the NCLT takes up those issues and passes order. In fact, the resolution professional is also entitled to the fees, because he has to administer the company, he has to safeguard the assets of the company, he has to do certain compliances which are required. The GST compliances would have arisen, the other compliances, the company law, and also the audit has to be performed. All those things are there. So such being the case, the insolvency professional is also eligible for the fees during this period. And any other question we have? Thank you. Okay, fine. So these are the questions we have answered, and how okay. Now we will try to go into the code. I will just skip to the code. The role of an IP is to collect all the information regarding the assets and liabilities of the business operations for 2 years. What invariably happens is there would be siphoning of money by the business owners. You know, you will take money and buy your Mercedes Benz. You will take money from the bank and buy your BMW SUV. You will take money from the bank and pay for the college fees of your daughter. You will take money from the bank and perform your daughter's marriage. All these issues where there is a diversion of fund, because of which the whole business has failed. Please understand, the banks are giving loan for the business, not for the personal use of the promoters, directors, etc. I know I am sounding harsh, but that is the reality. So what happens is, as soon as an insolvency professional is admitted, is appointed into the whole situation, there will be a forensic audit conducted. He will check the accounts as to why the loans went bad, why the business was not performed the way it should have been performed, why there are recurring losses, why there is a cash flow crunch, why these amounts were not repaid to the financial creditors and to the operational creditors. So there can also be a situation where a forensic audit is also done by the insolvency professional by appointing a separate chartered accountant or an agency who do the scrutiny audit, who do the proprietary audit, who do the forensic audit for the company. And where there are very clear cases to show that these things have indulged in the diversion of the funds, there might be requirement to ask the directors to repay those monies to the company also. There have been situations where BMWs were sold. I'm not I'm not quoting it off air. In fact, all these things are live situations where the insolvency professional has sought the permission of NCLT to sell 3 BMWs and 4, such luxury cars in order to bring back the money into the company. So all the fund diversion and all will become a very big issue, and he has to collect all the information for up to 2 years backwards, and he has to inform this information also to the NCLT and also to IBBI. And while collecting the claims itself, it would be obvious. Say only from the 18th month there has been a default in making the payment. We can immediately try to find out a few months earlier. Any trained chartered accountant can easily find out. No, sir, they can easily find out that there is a diversion of fund which is actually happening. So that is an important aspect here as well. So the committee of creditors will have all the financial creditors, and no related party will be there. In case you have taken money from your father-in-law, from your sister-in-law, etc., etc., these people will not come into the COC because they all become related parties. And there is an assignment of voting rights, which I explained earlier also. And one has to provide all the information to the COC, and the COC is the administering body under the chairmanship of the resolution professional, who will actually do all the administration of the corporate debtor as a going concern. So the committee of creditors, along with the RP, will do the management of the company as a going concern. Operating professionals will report to the professionals, and the professional has got the rights to appoint chartered accountants for forensic audit and for other audits, etc. He can appoint company secretaries for the compliances to be completed, and he can also appoint lawyers to file suits and also prefer applications before the NCLT for the recovery of the money or whatever it is. So the IRP is also liable to enter into certain contracts, amend the contracts, modify the contracts where the contracts are unreasonable. Or, for example, in my case, the registered office of the company was a huge thing in a very, very posh locality of the city, for which the company was paying around 4 to 5 lakhs rent every month. As soon as I became the RP, first thing I did was to shift the registered office to other smaller place where the rent is only about 20,000-25,000 rupees, and the company was immediately saved with about 3.5 lakhs a month or something like that. So such being the case, he can amend the contracts, he can modify the contracts, he can also enter into new contracts, and interim finance can also be raised where it is a going concern, and where there is an opportunity to do good business as and when is required with respect to the various operations of the company. And interim finance can also be raised subject to the approval of the COC. And of course, the resolution professional is in control of the company. Obviously, is also in control of the assets of the debtor. He has to list, monitor, preserve, and protect the manage and operations of the whole company. Such being the case, even either as an IRP or as an RP, even during the COVID pandemic, because of these reasons, they are eligible for the fee even during the pandemic reason. Because in spite of all the lockdown, whatever it is, the IRP has to perform his job with respect to preserving the assets of the company. If he has to visit the company, he has to do certain things which will ensure that the company's assets are being protected, monitored, etc., etc. So IRP 30 days and all we have seen, and once the RP comes, he will prepare the information memorandum as I informed, and he will invite the key stakeholders to put forth the resolution plan. All this must happen within 180 days. Now it can be extended up to 270 days, and now there is an amendment to show that it can be extended to a maximum of 330 days, including all the litigations. Whatever is the delay, it cannot exceed more than 330 days. But immediately after This amendment of 330 days has come in February. We are visited with the corona pandemic, because of which everything went haywire, and now this 330 days also has been increased to whatever 150 or 200 days as of now. And one has to make a resolution plan. If the resolution plan is approved, it has to be filed before the NCLT for approval. These are the situations. And liquidation, I'm not actually looking into it. Role of liquidator is there, but we don't have the time. And these are the various resolution processes we have under the code. I'm not going to go into them very deeply now. Let me see if I have any questions. Yeah, I have a few questions here. Whether an MSME can become a member of COC, if so, under what provisions? An MSME can become a member of the COC in case there are no financial creditors, all are operational creditors, and this MSME happens to be among the top 18 of the operational creditors. MSME can become a member of COC. Secondly, due to whatever reason, if the MSME has given loan to the company as a loan, as a financial creditor for whatever reason, MSME can become the member of COC. And MSME has got certain advantages, certain privileges in the resolution plan, and under section 29A, you can also have a look at it. Also have a look at section 12A, by which there are some privileges, advantages given to MSME which can actually use this to their advantage. Can an operational creditor ejected by the IRP be allowed once again without the confirmation or knowledge of the ID? I don't understand what is it at all, sir. The CD will come to have knowledge about any of the creditors, because the CD is allowed as an observer in all meetings of the COC. CD will have no say in the COC. The CD will have no voting rights in the COC. But the company manager, the company director, the company representative, the managing director, whoever is it, has got the right to be in the COC meeting. So there all these operational creditors are all discussed. The CD will also be there. I don't think there can be anything without the knowledge of the CD. Please understand, on practical grounds, it is not possible for the IRP to run the company. After all, we are all professionals, either chartered accountants, company secretaries, lawyers, etc., etc. We are not trained to run the company. How can I run a chemical plant? How can I run a steel plant? I would require the help, I would require the assistant, I would require the cooperation of the management in order to run. So, having without the knowledge of the CD is impossible, but there is no confirmation required from the CD. The balance sheet of the CD will speak of itself. The invoices issued will speak of itself. If the operation creditor has issued certain goods, the invoice raised by the operation creditor and the delivery challan issued by the CD is enough to show that he has to be in. Can an operation creditor rejected by the IRP? Yes, if the operation creditor can satisfy the requirements of the IRP, he can be allowed into the, his claim can be admitted. His claim can be admitted, I would say. Okay. The next question is, I think we are getting a lot of questions here. Okay. Sir, while RP is being appointed and active, whether any ED proceedings can initiate either against the company? It's an interesting question. One of my clients said that I am in the CRP process, so for traffic violation they cannot book me. No, only for this moratorium under section 14 is only for the business. If you have an issue with the other laws, you will have to deal with the issues. For example, being in moratorium, one indulges in contraband and is caught by the police. He cannot plead section 14 moratorium to escape. Only with respect to the business, only with respect to the entity, and the cases surrounding that alone is under moratorium, and there is no moratorium for everything. So in this case, ED can be proceeds if there is something else. Fine. D11 but not by company of resignation director whereas the ROC records show that they are still directors. Please clarify, sir. DNL Madhavan sir, I think this we can take it offline. I will be sharing my this thing. We cannot take it here because we have the next 10 minutes. Let me see if we have any other issues here, and then we will try to see it. And DR 11 and 12, we need to see whether the company has accepted the resignation. The company has filed it with the ROC. If the company has not filed it with the ROC, why within after 1 month the retiring director has not filed with ROC? All those issues has to be seen before we come to a conclusion in this query, sir. Thank you. And the moratorium we have seen, yes. The moratorium is only institution of suits and continuing of the pending suits against the corporate debtor. It does not include the basic issue with respect to the with the directors and others of the company. It is not so. That is what it is. This is what section 14 says. And somebody asked about the public announcement. Public announcement will have the following: name and address of the corporate debtor and also of the resolution professional, details of the resolution professional, last date for submission of the claim, etc., etc. Alone will be having, and it is a fixed format. So these things we will just skip. Transactions, as I said earlier, they where there are the related party transactions will be under scrutiny. Related parties cannot be under the COC. Contracts with related party will be scrutinized, if possible amended, if possible rejected, and if possible, you know, they will also be modified to the extent that it is to the best interest of the company. And these are the functions to be performed by the RP. Information memorandum is outside the scope, so need for RPs is not required. This is the main thing which happens. First, there is a default by the corporate debtor. As I said earlier, the trigger point is the default. Without the default, you cannot enter into the IBC. And default is a key to open the lock of IBC. That is how I explained it in my classes. The default by the corporate debtor has to be there, and there has to be an application. Either if it is an application by the financial creditor, then the interim professional is identified in the application. For an operation creditor, you don't have to identify the interim resolution professional in the application itself. The NCLT will appoint. And the IRP role has to form a committee of the creditor. He has to convene a meeting. He has to make an assets and liability, and the application is submitted. All these things are the role of the insolvency professional. He must preserve and protect the enterprise value in the calm period of 180 days. He must ensure that the value of the enterprise is protected. The valuation might not be in consonance with the Ranganathan sir. The valuation may not be in consonance with the book value of the company, but he has to ensure that the enterprise value is that there might be brands involved, there might be intangibles involved, there may be copyrights involved. All these things he must ensure to be preserved and protected for the 180 days. In fact, there are any infringement, he has to file the application immediately and take it forward. And this is the fresh order. This is for the individuals. Individuals, it is there. It is still not admitted, so we might take a pass on this. There is a fresh order, there is an individual insolvency, and the individual insolvency process. All of this is in chapter 3 and chapter 4 of the code. We'll just take a pass on this. I think with this, I have kind of completed within the time frame. I will see if there are any questions.
There's one question from Koteshwar Rao, sir.
Yes, I'll just open it now. Yeah.
You want me to read it for you?
No problem, madam. I'll read. In the given case, the CD itself is MSME. CD, if it is an MSME, he has got certain advantages. That advantages we have to look into it and see whether RP has any discretion to disqualify any resolution plan, while certain allegations against resolution applicants though do not come under 29A disqualification for IBC. Okay. Resolution plan is prepared by the resolution applicant. Please remember this. It is prepared by the resolution applicant, vetted by the resolution professional, and accepted by the committee of creditors, and is blessed by the adjudicating authority. I will just repeat it again. The resolution plan is always prepared by the resolution applicant who wants to buy out the company, take control of the company. The fresh person is the resolution applicant. The resolution applicant makes the plan and it is submitted to the resolution professional. The resolution professional goes through the plan, and if he is satisfied,
वो बास्केट के अंदर रहता, देखो बेटा, बास्केट के अंदर।
मैडम माइक ऑन है।
गटर में बास्केट है ना एक।
मैडम माइक ऑन है।
हाँ उस।
Yeah. So the application is prepared by the resolution applicant. Is gone through by the resolution professional. The resolution professional will make any changes with respect to facts or figures, and he will vet the document and will place before the COC. The COC will approve the resolution plan because the COC has to take the haircut. How much of haircut, how much of loss, how much of sacrifice the COC will make. Accordingly, the COC will approve the resolution plan. After the resolution plan is approved, the resolution plan will go to the adjudicating authority, which is NCLT in this case, for approval of the NCLT or the resolution plan. Such being the case, where there is any defect with respect to the resolution applicant, it can be brought up at any situation by anybody, because once the application is made before the NCLT for the approval of the resolution plan, anybody can implead into it and say that the resolution applicant is an interested party, resolution applicant is a related party, or whatever it is that can be taken up there. The RP will have the discretion to disqualify a resolution plan if he is able to identify, if he is able to satisfy himself beyond doubt that these things are true. On mere rumors, on empty unsigned letters, emails, WhatsApp, there is no requirement for the RP to act, for the simple reason he has to ensure that, as I said earlier, the intention of the act is to maximize the value for all the stakeholders. So such being the case, unless there is concrete information, he will not be able to act upon it. So any other question? I will see if anything is there in the chat box also, so that you can. Chat box, okay. Okay, thank you. So with this, I think we will come to a conclusion, sir, or can I go up to 6:30? The meeting says up to 6 o'clock, so I have completed my portion till 6 o'clock. If there are any questions, I'll be glad to take them, either online or offline. You have my coordinates here in front of you. You can just note it down if required. And I would like to place on record my very sincere thanks to the chairman, Corporate Laws and IBC of the Federation of Telangana Chamber of Commerce and Industries for according me this lovely and excellent opportunities. In fact, we had an excellent interactive session also in the chat box. I should really appreciate all the participants who have taken time off and interacted so very well. And also my my gratitude to the co-chair, Dr. Sharif, and also to the CEO, Ms. Kathy, for the opportunity, and for the and I think the president, Mr. Inani, has set the ball rolling for the presentation. In fact, I was actually wondering whether I should speak about the Banking Law Reforms Committee or not. I was just thinking, so I had some extra slides to also go into the code, into the nuts and bolts of the code. But I think the president set the ball rolling, and the expectation was very clear to say that the reason why the code was enacted also should be explained. And I really appreciate and I feel very honored to be in this August gathering. And thanks a lot for a very, very patient hearing. Thank you, sis.
I also like to thank Sri Ramana Kumar for patiently presenting and replying to all the various questions that the participants have asked these queries. With reference to the participants, friends, these are a lot of meetings which we keep having, and where we keep doing it for free registration. There is no registration or logging in cost. But I would like to invite all the non-members for this who have attended this meeting to please visit our FAPSI website, ftcci.org, and you can always become member of this great organization. And these are very few. You can join in with a very nominal fees and a lot of advantages being a member. It's not just a member of the Chamber of Commerce, but also you can do networking. You can do a lot of interaction, and Chamber will definitely act and represent you and your issues with either the state government or central government. So I think that a lot of advantages by becoming a member. So any of you who are interested, please visit the website, and that will help you a lot.
Mr. Naresh, our website address is ftcci.in.
IN, okay. So Tasnim ji, maybe you can propose a vote of thanks.
Yes, sir. I, on behalf of FTCCI, convey a very hearty vote of thanks to the speaker, Mr. Ramana Kumar, for gracing the seminar. I must really mention deep sense of appreciation to the speaker for explaining all the basics and procedures, which were very clear, crisp, and commanding. Sir, special thanks to our President, Mr. Ramakant Inani, sir, as well, and CEO, Ms. Khyati, and our own Chairman of Corporate Law and IBC Committee, Mr. Naresh Gilli, and yes, of course, our backbone, our backend team of FTCCI, and yes, a very active participation from all the participants. Thanks a lot to each and everyone. Thank you, sir.
Thank you, President. Bye.